Hello to all the participants today. My name is Steve Lambert. I'm the General Counsel here at GCFA. As you all know, since July 2015, employees around the country have been anxiously awaiting word on how the Department of Labor, the Wage and Hour Division, plan to revise the rules governing white-collar exemption from minimum wage and from overtime. There was speculation, as you heard and probably took part in, that the entire classification scheme would be rewritten. Ultimately, unfortunately, that did not happen. However, the Department of Labor has issued its final rule, and the consequences will still be significant to each of our organizations. There's going to be changes that are necessary, and for that reason, we have sent to each of the participants today a white paper covering what has happened. We're going to have this webinar today, and we're going to take steps in the future to answer all of your questions. And for those questions that are of applicability to all of us, we'll do a Q&A and keep it going so that all of you and all of the annual conferences and other organizations can keep up with this issue. Most of you know my friend and our friend Eric Stevens, who's a national known employment lawyer in a law firm of Littler Mendelson PC. We've asked Eric today to walk us through the final rule, its implications, and its application. This is still a complicated area, and we will, at the end of this presentation, be discussing what I think is a very exciting opportunity that we here at GCFA have worked through with the Littler Law Firm, a way to automate your decisions in a cost-effective and efficient way that hopefully will help you get through this morass and to the other side. So let us now turn to Eric, and we'll hear his presentation. Thank you.
Thank you, Steve. It is always an honor and a privilege to speak to this group. And the topic that we're speaking on today is one that, as Steve pointed out, has been highly anticipated. A lot of speculation that has gone into that, and regardless of how often we talk about the issue, regardless of how often we go back over some of the concerns, it's always a very complicated issue. It's always a very difficult issue to address. And as I tell most of my clients, if you give me enough time in your workplace, I will find wage and hour violations. It doesn't matter that you are trying to do things the right way. It doesn't necessarily matter that you've conducted a complete wage and hour audit. There are so many complicating factors. There's so much individual opportunity for errors to occur that wage and hour issues are difficult enough regardless of changes in the law. And now we also are called on as employers to deal with a new change in the Department of Labor regulations that will profoundly affect how we treat, how we classify, and how we compensate employees in the exempt classification area. Very quickly on our agenda today, we're going to talk a little bit about the background to give you a little review of how we got here, so that everyone will sort of be up to speed on that same situation. We're also going to look at the rule itself, the final rule, and how it implicates not only the minimum salary requirement, but how that can also have some application to other aspects of the exempt status. We're going to look at how we as employers need to prepare for changes. Not simply looking at numbers, but also how do we work through the interpersonal relationships that we have with our employees, and how do we roll this out, and how do we train our supervisors to maintain this. And then we're also going to look at some various options that we have. Steve mentioned an automated option that I think is an excellent option for employers to use, but also options to consider as far as restructuring positions and when it may be necessary to actually treat someone as non-exempt rather than exempt for various reasons. So a very quick review. What we're talking about with respect to exemptions are the white-collar exemptions. There are a number of them. The three primary exemptions that we deal with on a day-to-day basis are the executive exemption, the administrative exemption, and the professional exemption, which can either be the learned professional or the creative professional. Those exemptions are all creations of statute, but they are developed by regulation, by the Wage and Hour Division of the Department of Labor. And because they are developed by regulation, they can be changed. from time to time. And as most of us are familiar with, there are three different, if you will, legs of a stool, three different considerations for white-collar exemptions. For any of these three, there is a salary test, which is a salary level. There is a salary basis test, which ensures that employees are paid a certain minimum amount without certain deductions, regardless of the number of hours that they work. And then there is a duties test. Now, while the final rule primarily affects the salary level test, I think it's very important that we look at these other aspects to see how they interact with the final rule and how it's been affected. The rulemaking process, I'm going to move through this slide fairly quickly. In essence, this is something that employers have been struggling with for over a year. There was a lot of speculation about what might happen. The Department of Labor did not make things any easier by the way that they asked questions without proposing particular rules. There was a lot of speculation, and unfortunately there were some employers that just went out and started changing things. Not the best approach, but certainly a proactive approach. Bottom line is, as of May 18th of this year, the final rule was issued. The final rule is going to be effective December 1, so we have a little bit now less than 5 months for employers to prepare for and to address the rule. Before we get to the Department of Labor rule, however, it's very important that employers, particularly not-for-profit employers, assess the coverage of the FLSA. The Fair Labor Standards Act does not apply to all employers. The Fair Labor Standards Act may apply to nonprofit organizations as well as for-profit organizations, but there are two different types of tests that apply to determine whether the FLSA applies. There's what's called the enterprise test, which looks at an entire organization, and if the enterprise test, or if the FLSA applies by virtue of the enterprise test, then the entire enterprise is covered. There is also an individual position test that we'll look at, and if those individual positions are covered, the rest of the enterprise may not be covered, but still some select positions within an organization may be covered. So let's look a little bit first at the enterprise coverage. It's very important for not-for-profit organizations to understand that for the Fair Labor Standards Act to apply to you as an enterprise, there must be gross revenues from commercial activities of at least $500,000 annually. That is commercial revenue. It does not include offerings. It does not include donations. It does not include grants. And so a lot of, or at least a significant portion of non-for-profit organizations may find that they are not covered by the enterprise coverage test simply because they are not generating income revenue from commercial ventures that would bring them under the enterprise test. Now, there are some enterprises that are covered regardless of whether, or regardless of the amount of revenue that's generated, regardless of whether it is from a commercial activity. Two of those that are of particular interest to not-for-profits of a religious nature would be schools. That would include preschools that may be run by churches, may be run by organizations. That would also include hospitals. Both of those are what's called listed or named enterprises, and those enterprises are covered regardless of whether there is $500,000 in actual revenues from commercial activities. The issue of enterprise coverage and how far it extends is truly a function of the corporate structure of the particular entity. For example, if a church operates a preschool, operates a preschool setting, and that preschool is completely separate, it has its own corporate identity, it has its own EIN number, it has its own organizational and supervisory structure, and is separate and apart from the church, then it is unlikely that the church would be covered under the enterprise test. However, if the preschool is run simply as an extension of the church, there is no separation whatsoever, then you may find a situation where a church could be caught under the enterprise coverage test because they are operating a school that would be a listed test, even though they would not, most likely would not be anywhere near the $500,000 level for coverage. Beyond the enterprise coverage is also the individual coverage. Again, if an employer does not fall under the enterprise coverage test, there may still be some employees of that organization who are covered by the Fair Labor Standards Act. Typically, these are employees that are engaged in some sort of interstate commerce. That becomes a very fact-specific analysis as well. The Department of Labor has been fairly understanding, particularly towards not-for-profits, particularly towards religious not-for-profits, in giving a pretty wide berth as far as whether employees are engaged in interstate commerce. If an administrative assistant picks up the phone and makes an interstate call, that does not automatically make he or she covered under the individual test simply because they've made an interstate telephone call. However, if the individual, as one of their primary duties, is to purchase for an organization, and those purchases are made via interstate commerce, then that individual very well may be covered by the FLSA, even though the organization would not be covered under the enterprise test. I've received a couple of questions emailed earlier. Does this mean that we should tell everyone not to make interstate phone calls? The answer to that is no. The Department of Labor, again, is very reasonable. But the one thing that I want to make very clear is, with respect to everything that we're talking about today with the Fair Labor Standards Act, we're talking about Department of Labor enforcement and oversight, but there is also a private right of action. And while the Department of Labor may be more gracious, may be a bit more generous to religious not-for-profit organizations, that does not mean that an individual who feels disenfranchised could not go out, could not hire their own attorney, and could not prosecute a case and perhaps not be so gracious. So we need to keep in mind that while the Department of Labor has a certain bandwidth that they allow us to work within, we still need to make sure that we're working within the parameters of the regulation itself. And so individual coverage, again, is something that needs to be examined very closely. Do not simply assume that if you are not an enterprise covered, that none of your employees are covered. That would be an incorrect and an invalid assumption. There is what is known to be a ministerial exception. Now, first of all, keep in mind, it is not a statutory exemption. Neither Title VII, ADA, ADEA, nor the Fair Labor Standards Act contains a specific statutory exemption known as a ministerial exemption. However, courts, from local courts all the way up to the United States Supreme Court, have recognized that the First Amendment, both the establishment and the free exercise clauses of the First Amendment, make it appropriate that for some limited group of positions, that there should be a ministerial exemption due to the ecclesiastical, if you will, nature of those particular jobs, and the court will not allow wage and hour to interfere with those positions. But we need to be very careful because that exemption is probably not as broad as we would like to try to apply it. You have here on your slide now a case that is a little over a year old now. It is actually not a case that was decided under the Fair Labor Standards Act. It is a case by the U.S. Supreme Court, the highest level of determination of a ministerial exemption of any court, but not for FLSA. This is actually the exemption under Title VII. But you can see there are 4 different criteria to be examined in determining whether a ministerial exemption may apply. The ministerial exemption would take that particular position out of the purview of the FLSA. This is not an exemption such as an administrative or an executive or a learned professional. This is an exemption completely from the FLSA. But you'll notice a couple of things that I think are very important. One is certainly not only the individual's title. The term minister in and of itself is not going to be dispositive, but does the job require specific training? Does it require theological background? Does it require seminary training? Does it require licensing as a minister? The substance of the position itself and its function within the church. Certainly how that position sets itself out, if it is treated as exempt for tax purposes, where there actually are some exemptions from tax purposes. And then number 4 is probably as important, if not more important than the other 3, and that is the degree to which the position actually conveys or perpetuates the ministry of the religious organization. It is, again, there are no there are no black and white lines where you can say this is and this is not. You need to be very careful in applying the ministerial exemption, and be even more careful if you try to move that exemption beyond the traditional licensed ministers, those that are actually perpetuating the gospel, as opposed to positions that may be more administrative in nature, that are no question are supporting a ministry, but in nature are truly more of an administrative position that may not require theological seminary training and the like. So the ministerial exemption is out there. It is not nearly as broad often as we would like to think that it might be. There are a number of other religious workers that oftentimes come into question. And I'm going to just list these for you. I'm not going to try to answer all of the questions at this point. There's actually a separate exemption altogether for camp counselors. And so if you are operating a camp and that camp is a completely separate organization, there are some calculations that have to be made about the revenue of the camp. The revenue cannot be more than 33% of the total revenue for the entire year, and the camp cannot be open for a 12-year or 12-month period. It must close for some period of time. That exemption may apply, but that applies to camps that are recreational in nature. Camp counselors may be exempt, not exempt from the FLSA, but may be exempt as executives. They may be exempt as administrators, but it is not automatic. And camp counselors typically would not fall under that ministerial exception unless there is some ministerial component to it beyond simply making sure that the kids don't drown each other in the pond. So you've got camp retreat, support folks, and again, that becomes a bit more difficult as well, because that, while again, no question, all of these positions to some extent perpetuate the ministry, which is a wonderful thing to do. From the purposes of the ministerial exception, it does not go that far. Choir directors, church musicians, situations like that, again, those become a little bit more difficult because for the most part, it's not an issue because they're not working 40 hours. But there may be some circumstances where for a short period of time, they may work more than 40 hours. Again, a minister of music most likely would fall under the ministerial exception. A musician that may play part-time for the church, may play part-time in other genres, probably somewhat less likely to fall under the ministerial exception as would certainly a minister of music. So let's look a little bit at the DOL's final rule. The good news is, as Steve mentioned, there are some things that are not changing. The determination of what are the primary duties of the positions is not changing. There was some concern that we might go back to a greater than 50% or a formulistic how much time do you spend each day doing each duty and calculating those to determine what the primary duties are. None of that has changed. But what I will tell you is because it did not change, wage and hour division is going to hold employers to a much higher expectation of compliance. There is no excuse for not knowing the rules that have been in place since 2004. While an employer might get a pass saying this is a brand new rule, I didn't understand it or apply it properly, as employers, if the FLSA applies, we are still under rules that have been in place for over 12 years. And so there is going to be a heightened expectation of compliance, very little grace, very little forgiveness coming out of the Department of Labor wage and hour. There were no changes, again, to either the definition of primary duty or to the way that those primary duties were calculated. However, the change was to the minimum salary level. Those of you might remember the minimum salary level used to be $455 a week. It has now been increased to $913 a week, $47,476 annualized. Someone had asked me earlier, can that be prorated? In other words, if we have employees that their, quote, regular work week is 36 hours, then can we prorate that $47,476 down to whatever percentage that is of 40 hours and use that and still maintain the exemption? And the answer is no. This number cannot be prorated. It cannot be reduced even if an employee works a 20-hour work week. Now, if the employee works a 20-hour work week, they're most likely not going to be entitled to overtime anyway, So that part isn't an issue, but keep in mind that even if you have employees who once were exempt and now are not exempt, even if you do not have overtime obligations, as an employer you still have timekeeping, record-keeping obligations that you did not have when those employees were exempt. Non-exempt employees must maintain accurate time records. Actually, the employer has that obligation, but you have to get that information from the employee. So there are still obligations even if the employee may be non-exempt but not working overtime. So don't think that just because you have someone that works less than 40 hours that this doesn't really matter if they're misclassified. It really does. Now, you'll see the way that the wage and hour has set this 47,476. It is the 40th percentile of a group of states. For whatever reason, I don't know whether we should be proud of this or be insulted by it, but they have decided that a group of, quote, southern states will be used as the comparator for this 40%, or the 40th percentile. Now, while that the thought process, and actually the way that it was rolled out, was that this is a lower compensated area of the country than other areas of the country. To some extent that may be, but keep in mind that the Department of Labor's idea of the South includes Maryland, includes the District of Columbia, and includes Virginia. While technically they were part of the South, they were part of the Confederacy at one point in time, except for the state of Maryland. They are probably three of the highest paying states, or two of the highest paying states, and the highest paying district in the United States. We're talking about that area right around our nation's capital. So the notion that this is a lower paying band, and therefore the 40th percentile is a lower number, is a bit fictitious because they have factored in some very highly compensated areas of the country. That is a number, by the way, that will be calculated by the department every 3 years. One of the things that is a little different in determining whether an employee is being paid the minimum salary, the $47,476, is whether they're also receiving any sort of, under the regulations, it's bonuses and commissions. I realize that most of the organizations represented on this call do not pay commissions. This is not the Great Commission. This is commissions on whatever it is that you're producing. You probably don't pay those. You may have some other incentive payments that would be a component of an individual's compensation. You can use those additional components up to 10% of that 47,476 to meet that number. But there's something that's very important to keep in mind, and that is these have to be non-discretionary, and they also have to be paid on a quarterly basis. So in other words, if you have employees that only receive incentive payments at the end of the year, they receive some sort of a performance bonus at the end of the year, those dollars cannot be counted in on those quarters where they are not paid. So keep in mind if you think that you're going to count in any part of the non-discretionary bonuses as part of the 47,476. And again, you see how this works on the slide. I'm not going to spend a lot of time on the math, but if there is anything that, if there is a quarter where that bonus does not get paid, the employer is permitted to make it up, but you have to make it up in the very first pay period of the next quarter. So you can't wait, again, you can't wait 3 quarters and then make it all up at the end. So you wind up only being able to use non-discretionary bonuses. This may be useful to some, but for the most part it's very difficult, very tedious calculation. Those of you who have found yourself in the highly compensated employee group, bless your heart. If you are paid over $134,004 after December 1, then your duties are not so much of a concern for the Department of Labor. There's a determination that once you hit that number, you're probably earning your money, or maybe you're not, but nobody really cares because you're being paid so much. In any case, that number has gone up about $120,000 as well. If you have folks who are below $134,004, their duties are critical, because it doesn't matter if they're making $134,000 and you're not paying them that extra $4, they still fall under that highly compensated number. So keep in mind that that's really the bandwidth as far as where the exempt employees can land now, is between 47,476 and 134,004 with respect to determining what do those, are we complying with the duties test. Something else to keep in mind, and this is really, there's a couple things that go with this. One is sort of a philosophical issue, and the other is a planning issue. And that is, every 3 years, beginning in 2020, the Department of Labor is going to announce a new number as a minimum salary number. That new number will be the 40th percentile, and if you do the math, it will never stop. Because as soon as you move everyone's minimum salary up to a certain point, it is no longer the 40th percentile. It is the 100th percentile. And so that number will continue to move up every 3 years. So if you are making the determination, should I begin to increase people's salary to pull them into the exempt salary level, understand that you are starting yourself on a process that will be, and clearly it is an intended inflationary component. And so if you begin to chase that rocket, understand that you're either going to kick the can down the road for 3 years, or at some point in time you're going to have to decide, are we going to bring people down, or will we continue to follow this number up every 3 years? The other thing that makes it difficult is that this information is going to be published by the Department of Labor no less than 150 days prior to January 1st of the effective year. My math tells me that that's around August the 3rd. You can be rest assured that with being the federal government, it will be no more than 150 days before January 1st, 2020. So the other difficulty with that increase, the perpetual increase, is that's going to hit in August. You have to consider when your fiscal year is, when your budgetary year is, and how will that impact you as far as planning. Are you going to try to build in that component before the period starts, or are you simply going to go over budget for the last 6 months if you have a January 1 budgetary process? Again, the effective date of this is December 1, 2016, but keep in mind some states require advance notice, particularly if you are downgrading positions. If people are going to be making less, states such as, and I think I've listed up here, Missouri is I think is the one that has the longest requirement, and that's 30 days for any reductions in pay. But keep in mind that you will have to plan for this and also have to give notice for it. So what are we going to do to prepare for the change? The last session that I spoke to, I asked how many of y'all have been tracking the hours worked of your exempt employees to determine if you have to do a cost-neutral calculation, how many hours you'll be budgeting in for that. As you might imagine, there were very few hands that went up. In fact, unless someone raised their hand on the phone that I didn't see, the answer was none. That is not an unusual response. Employers have really been sort of taking a wait-and-see approach, but now it's time to no longer wait. It's time to no longer see. The new rules are not going to go away. It is absolutely critical that, first of all, we determine who of those positions that we are treating as exempt truly are exempt. And that starts not with the money, it starts with the duties. Because it does not matter how much money you throw at someone up to the $133,004, if they do not meet the duties test, they are not exempt. They are simply being compensated a lot. And what that will mean is when you get hit by either an enforcement action or by a plaintiff's lawyer for overtime, it means time and a half on those types of rates are significant. So it starts with evaluating the duties of the positions and ensuring that those are properly classified. At some point, we have to start looking at where that cutoff is, and do we want to increase salaries of individuals to push them in, assuming that their duties match, or do we want to pull those folks back or keep them where they are and thus have to treat them as non-exempt? Not because their duties have changed, but simply because they're being paid less than the $47,476. December 1st is going to be here before you know it. In fact, I was at a Target the other day, and they were already starting to put out Halloween decorations. So we're going to be seeing Christmas decorations pretty soon, and we'll be seeing the DOL as well. As far as identifying the jobs that we need to be looking at, let me go back one other screen before we do that. On sort of a step-by-step with the compliance, we're going to have to identify which of these jobs that we're going to classify. We may have to actually develop a new compensation plan, keeping in mind that there are more options than simply salaried or hourly plus overtime. There is the possibility of what's called a fixed rate for a fluctuating work week, which is a salary plus half time for any hours worked over 40. That's often a good midpoint for folks that have been accustomed to being salaried, who find the salary position as a status as well as a compensation form. And so you're going to have to determine what is the most cost-effective way to do this, but also what is the most acceptable way. We're going to have to look at some policies. We're going to talk about that. We're going to talk about how we communicate those changes, keeping in mind, again, that some of these changes are not simply dollar changes. They are status changes. They are emotional changes. They are challenges to my worth, to my value to the company. And so how do we communicate that? How do we manage it? And then also, how do we train both supervisors and employees who are now non-exempt? It is quite likely that we're going to have employees who, for whatever reason, worked at their own pace. They were never concerned about efficiency. They were never concerned about the time it took for a project because they were on salary. They no longer have that luxury. We no longer have that luxury. And so to that extent, how do we train our folks? How do we supervise our folks? How do we manage overtime in the context where in the past overtime was not even a consideration? So again, the jobs to start reviewing are the jobs that are within that bandwidth. We start between the 134.04 and the 47.476, and we look at those jobs to determine, are they fitting the duties test? If they're not fitting the duties test, again, it does not matter how much we pay them. Then we also look at the bandwidth just below the 47.476. Are they meeting the duties test? If they are not meeting the duties test, there is no reason to increase the salary to 47.476. It will have no implication whatsoever on the exempt status of the employee. We may also need to identify those positions that are either so far below 47.476 or that simply do not meet the criteria to justify raising that number up, and how do we deal with those? Keeping in mind there will always be a ripple effect when we begin to adjust salaries. If we adjust salaries upwards, there is upward pressure on everyone else who is above those salaries. If we adjust salaries downward, there is a downward pressure on those salaries. Keeping in mind other statutes such as the Equal Pay Act, Title VII, if we are not paying individuals in a comparative basis, and if proof can be shown that it's either because of gender, which is an equal pay claim, or any other of the protected classes, then there could be litigation to follow from that. So we need to keep in mind that there are ripple effects that go with that. So before we get to how do we calculate the numbers, we always want to go back to the duties. We're not going to get really granular on this, but just keep in mind the executive position is typically a fairly easy position to determine. There has to be some degree of authority, some degree of the ability to hire, to fire, to discipline, to direct, and that has to be exercisable over at least 2 full-time employees. That does not mean that only the person with the ultimate authority to terminate is an executive and no one else is. We all have a boss. But there has to be some level of the ability to direct, the ability to discipline, and possibly the ability to terminate. And there has to be 2 FTEs. You cannot be a chief with no Indians. There must be at least 2 FTEs for this to apply. The administrative test, probably the most widely misapplied, the most widely misunderstood, or oftentimes perhaps maybe asking for forgiveness rather than permission. But regardless, the administrative exemption is widely misapplied. Employees, and we're going to talk a little bit about some examples of misapplications, but the employee has to have a responsibility that typically is not a direct production responsibility, but is what I use the term as a dotted line type of responsibility. But it has to have still has to have some substantive import or impact on the management of the department. But the thing that's probably more important is this second bullet point, and that is that it allows the employee to exercise significant independence and judgment in a matter of significance. Now, that does not mean that we tell people what you do is not significant. It is not important. But the flip side to that is if an employee is simply applying a predetermined set of criteria to a set of circumstances, that individual is not an administrative exempt employee. If my administrative assistant has the authority to put a meeting on my calendar at 2 o'clock instead of 3 o'clock. That may be some degree of discretion, but that is not going to make him an exempt employee. If that individual has the ability to determine whether I meet, who I meet with, the purpose of the meeting, and that I can direct the other people to come as well, then we might have something to talk about. But typically, administrative exempt does not simply say if your title has administrator in it that you're exempt. The professional duties, the learned professional is pretty easy. Typically, it requires some sort of an advanced degree, an advanced course of study. Creative, again, deals with inventions, imagination, originality, talent, things that I should not ever try to speak on with any authority. Computers is the only thing that I have even less experience on than creative talent. So let's go on to, oh, by the way, if your organization has outside sales employees, that may also apply. There is no salary requirement. I put these duties up only to sort of go through the list. But this is a requirement that the employee actually perform their services outside of the work and that it be sales, or outside of the workplace and it be sales related. Some common misclassifications. Administrative assistants. I will tell you that if the Department of Labor comes to do an audit, they are going to ask for a list of the names of administrative assistants, they're going to ask for their time records, and they're going to ask for their job duties, and then they're going to ask to interview them. That is standard for wage and hour audits because administrative assistants are typically misclassified in most employment situations. It does not matter if you make your administrative assistant an executive administrative assistant, unless that executive administrative assistant is supervising other administrative assistants, then they may truly be an executive. But the point of that is simply adding a title of executive does not automatically make someone an administrative assistant. Similar to what I mentioned earlier, directors with no subordinates. Director title is a great title. Folks have that, God bless them. But nonetheless, if they are not supervising someone, they are not exempt. And so we need to keep that in mind. The last one is folks who have always been exempt. Even if my assistant came over on the Mayflower and was being paid a salary at that point in time, it does not matter. If they do not meet the duties test, then they are not going to be properly classified. So then the question becomes, do we actually increase the salary? Do we go to overtime? And there's some different calculations that can be done, but this all goes back to determining how many hours are the positions working that are in that area, say just below, within whatever that bandwidth is that your particular budget can withstand to increase those salaries. That's the bandwidth that you want to look at to ask yourself how many hours are they working? Can we actually pay them overtime and make that a cost-neutral change, which is absolutely appropriate and absolutely permissible by the Department of Labor. You do not have to simply take whatever their salary is now, divide it by the number of hours they work, and that's what you have to pay them. That is not required. You can go back and recalculate hourly wages, hourly rates at this point. And again, overtime is going to be time and a half if you're paying on straight time. It's going to be half time if you're doing the fixed rate for fluctuating work week. You see the explanation for the cost neutral solution, and I'm not going to go through all of that, but again, you just divide, you take the total amount of hours, you divide that into the salary, and then you go back and figure out how much you're going to be paying with overtime, and then back that into your hourly rate to make sure that there's no change in the salary if you want to do that. To review the jobs, you're going to have to get more information than simply what are they doing now or simply an assessment of what they're doing. You need to be talking to supervisors. You need to be talking to the employees themselves and get a better idea. If you have not done some time study, it is lawful to do it. You're not going to make everyone non-exempt by asking them to track their time for a period of time just to allow you to make those assessments. You may have to redesign your compensation plan, and that's where we'll talk a little bit more about that in just a minute. But what I do want to take us to now is something that we are very honored to be able to partner with GCFA in providing and offering a product that Littler has developed with another corporation. It's called Compliance HR, and you're going to see some slides here. You're going to hear a couple of ladies speaking. Let me just do a little bit of an introduction on that. The two ladies that you're going to hear speaking, one is Lori Brown. She's actually the president of Compliance HR. The other is Tammy McCutcheon. Tammy is one of my shareholders, one of my partners at Littler. She is a nationally renowned expert on wage and hour. Before she joined Littler, she was a former administrator of the Department of Labor, and she was actually one of the authors of the revisions in 2004 to the regulations that were in place, some that still are in place today. So she is a preeminent expert, and the two of them are going to be explaining a computerized solution that is much quicker, much more cost-effective, and much more consistent than anything that human attorneys would be able to produce.
So Compliance HR combines the incredible subject matter expertise of Littler Mendelsohn with the revolutionary expert software system of Neotologic. Our solutions are expert systems, meaning they emulate the expert thought process. In the instance of Navigator OT, this solution emulates, well, frankly, Tammy McCutcheon's thought process. But first, let's take a look at the OT cost estimator. This tool helps you with the math involved in making the salary increase versus overtime decision. The OT cost estimator application helps users decide how to treat exempt employees currently earning less than the $47,476 by calculating the estimated cost of raising an employee's salary to meet the proposed 2016 minimum, reclassifying the employee as non-exempt and paying overtime at the same salary level or hourly rate equivalent, or reclassifying the employee as non-exempt but setting the hourly rate to minimize additional labor costs. We call this the cost-neutral solution. So here are a couple of screenshots. So the application has already been updated for the minimum salary level in the final rule. You are asked to enter information about an employee's current salary, bonuses, and commissions, whether you want to roll all or some of the employee's bonuses and commissions into base pay in order to minimize additional costs, and the number of overtime hours you expect the employee to work. In second, you will know whether it will be more costly to provide the salary increase necessary to maintain the exemption or to reclassify and pay overtime. The application will also give you that cost-neutral hourly rate that Tammy discussed. Turning now to Navigator OT. Navigator OT is part of our Navigator suite and delivers what was just years ago unimaginable: an expert exemption analysis under both federal and state law, powered by a logic engine based on over 1,800 reported cases, expertly dissected and applied in a matter of seconds. That is the unprecedented and proprietary power of Navigator OT. So now you have world-class expert analysis powering and validating your internal process, allowing you to be immediately responsive to internal partners while preserving more of yours and your team's bandwidth. Navigator OT gives all of you the ability to efficiently assess whether an employee is likely to be considered exempt from overtime requirements under federal and state law, as well as determine how to treat exempt employees earning less than the federal minimum salary required to be paid under most common exemptions. This is the first of its kind online exemption analysis delivering expert-level guidance at internet speed and scale. Typically, an exemption assessment can take hours, but with Navigator OT, the assessment can take as little as 15 minutes. After completing an easy-to-use online questionnaire, Navigator OT applies all applicable federal and state exemption tests. In addition to the assessment, Navigator OT provides expertly reasoned suggestions on how to lower the risk of misclassification. Together with the assessment, Navigator OT provides a summary of the federal and state exemption standards, together with a transcript of answers to the online questionnaire. So just to give you a quick glimpse on how it works, this is a web-based solution that includes dashboard drivability to manage, monitor, maintain, and retrieve your results 24/7. Navigator OT allows you to evaluate employees one at a time or by large batch, and by employee or by position. Quickly and efficiently, Navigator OT takes our user through the minimum salary compensation check and then simplifies and screens for applicable exemptions and dynamically builds out remaining relevant questions. So let me pause here for a moment and just point out that this is a radically different system than just picking up the phone and calling a lawyer or performing your own legal research. It is an entirely different delivery method and model for compliance expertise. It is next-generation technology applied to today's compliance issues. And if past this prologue, we know that intelligent employment applications will very soon be part of our everyday go-to apps, not unlike the apps that we use now that just a year or two ago seemed futuristic. So whether you come from a company with an aggressive appetite for technology, or you're just starting to ease your way in, whether you need a solution to validate your current process or to conduct an audit, or you just want to develop a workflow for onboarding employees, this technology, this solution can now power your objectives in a way never before available. But Tammy, like anything new, using an online expert tool may feel very different for some of our listeners, but should it feel different? And along those lines, perhaps I could get you to jump back in here and help me explain, how does Navigator OT think like an expert, and how do we know it's accurate?
Lori, you can imagine my reaction when I was first approached about creating an online solution to replicate my thought process. I have spent most of my career practicing wage and hour law, and now you want me to replace myself with a robot. Well, I didn't think it could be done. I was very skeptical. And isn't that just the typical reaction to disruptive innovation? But I also know that technology must be the answer to quick and cost-effective compliance. So I put my head down and I did it. I'm proud to say that Navigator OT will provide such value to my clients. I am sure they will still call and ask my advice on the more difficult questions. On the screen now is the heart of the solution, the duties test analysis. And here is how it works. Littler attorneys read and analyzed over 1,800 court decisions to extract the job duties that the courts discussed and to determine whether the court found that the employees performing those job duties were exempt or non-exempt. Then we use the Neoda Logic platform to create logic tests applying the state and federal laws, regulations, and the court decisions. Of course, the solution is only as good as it is accurate. We ensured that accuracy by having Littler wage hour experts test run scenarios through the solution. And by running fact patterns from the actual cases through to ensure that our solution reached the same results as the courts did, we ensured a very high level of accuracy. The results surprised even the experts. We couldn't be more proud about what we've created with Navigator OT. Lori, can you show us how Navigator OT delivers its results?
Sure, Tammy. So for all of us who have ever found ourselves poring over regulations, poring over case law, job descriptions, emails, and frankly pulling our hair out in the process, and then having to spend hours to drive towards a conclusion, still not quite sure, maybe not quite confident in our analysis, here's the smart alternative, the smart solution. And here we go. Here's your answer. Expert-level analysis derived from all applicable case law, expressed in a vivid, understandable way. So upon completion of the questionnaire, our solution produces an expert assessment that tells us the strength of the particular exemption eligibility. Here, for example, Navigator OT concludes the employee is likely to meet the requirements for the executive exemption. The solution also provides separate risk levels by all available exemptions. Finally, Navigator OT delivers 3 additional resources to facilitate and document your exemption decision. First, we couldn't deliver a result without explaining what it meant and, importantly, what could be done around it. Understanding your risk is a dynamic memorandum identifying the facts that are most driving risk. In this report, the administrative exemption risk is higher because the employee performs work which does not require discretion and is required to follow manuals. So you can use this report to uncover how job duties can be restructured to come more clearly within an overtime exemption. And of course, we provide a summary of all applicable state and federal law, and finally, the transcript of questions and answers. So when a user completes the questionnaire, this can be a powerful defensive tool if your company is ever faced with misclassification litigation. So here we have it, folks. You have an automated, intelligent tool that conducts this analysis, shows you the reasoning, and gets you to the answer without breaking the bank and blowing your budget. So now that we've seen the solution, I suspect that some of our listeners might be wondering why they'd want to perform any duties analysis given that the new rules focus more on the minimum salary requirements. So, Tammy, I'm going to ask you to jump back in here and tell us what's your insight there, and how does Navigator OT factor into your recommended strategy?
Lori, you should use Navigator OT to get your house in order while you have this rare opportunity to make changes under cover of the new regulations. We all know that reclassifying employees can be tricky business, and now is your chance, I dare say your obligation, to protect your company by helping to ensure your exempt employees would and will withstand scrutiny when a plaintiff's lawyer or the DOL comes knocking. Anytime a law changes, there is increased and heightened focus by plaintiff lawyers, employees, and regulatory agencies. When asked by an enforcement agency or a plaintiff's lawyer what you've done to analyze your exempt workforce, your answer must be creditable, auditable, but most importantly, you want to be right. And by virtue of the fact that all of you have taken the time to join this webinar, that tells me that you all know that doing nothing is not an option. All of you are listening in because you are compliance-minded, and for the enormity of this once-in-a-decade opportunity, there's no reason not to get your house in order during this window. And through Compliance HR, you now have the means through technology to analyze your positions at internet speed and scale, and with my level of expertise at a small, and I mean a small, fraction of what a traditional analysis would cost. So pick a percentage of your exempt positions, or perhaps the positions with the highest number of incumbent employees, and use this tool to correct any mistakes during this once-in-a-decade window of opportunity.
Steve is going to come back and talk a little bit more about this opportunity that we are very fortunate to be able to offer through GCFA. But I do want to go through a couple of other things to consider as far as preparing for the changes that are coming up. Once you have analyzed the duties, once you have made the calculations to determine whether or not it is appropriate to increase salary, to reclassify, or what have you. And this is where you really see the full brunt, if you will, of the change in regulations, but also, again, keeping in mind that we are going to be dealing with a very aggressive DOL. And that is, you need to be looking at your policies, you need to be looking at your processes. The notion of off-the-clock work is probably something that your employees that are exempt or have been exempt have no concept of and no concern for. Likewise, some of the folks who have been supervising exempt employees may not have that concept or that concern. It will now be a concept. It will now be more than a concept. It should be a concern. Things such as meal break. We did have a question about travel time, and so let me address that very quickly. The question that was posed was, is travel time compensable? That is a very complicated answer to a very simple question. I'll give you the 50,000-foot view. If the employee is traveling between work sites after going to that employee's first work site, all of that travel time is compensable. These all, by the way, deal with non-exempt employees, not exempt employees. If the employee travels away from town overnight or away from their normal workplace out of town, that travel time will be compensable if the employee is actually driving. It will be compensable if the employee is riding and the travel time cuts across their regular schedule, even if it might be that if they typically work 8 to 4, even if they're traveling on a Saturday or a Sunday, if the travel time cuts across that 8 to 4, whatever that period of travel time is, that's compensable. If the employee is doing any sort of work while they are traveling, that is also compensable work time. So you have travel time. Mobile devices are going to be a huge issue with the Department of Labor. If you do not have a policy that regulates non-exempt employees' use of mobile devices, you need one, because the next thing that the Department of Labor is going to come after is off-the-clock work by folks who are hopefully not texting while they're driving, but certainly accessing their employer's computers, their employer's electronic data and what have you from their own personal electronic devices. Your processes for timekeeping. Employees that were exempt are not going to be used to tracking time. Supervisors are not going to be used to managing time. All of that needs to be covered. Also, it's very important to communicate these changes, both communicating them to the supervisors as well as the folks that are affected, also communicating them in a way that folks understand this is not a disparagement of what they do, and also being prepared for the question of, if I'm being paid overtime now, why haven't you paid me overtime for the last 3 years? That's a question that you need to be prepared to answer. You need to prepare the supervisors for those answers. Make sure that you have some talking points, some FAQs. Make sure that you're training your employees, particularly those who are reclassified, on these procedures. And so now I've tried to save us a few minutes for questions. Some folks have already emailed questions, 2 of them that I received very quickly, and then I'm going to turn this over to Steve again. But the first question is there a professional musician exemption? There is as I mentioned earlier, there is a creative professional exemption, and I think that's probably what you're thinking of. And yes, in fact, that may a musician may fall into that creative professional exemption. So that's something to consider. The next question was, can paid staff volunteer without pay? I assume was the implication. The answer to that is yes, paid employees may volunteer work for a nonprofit only. If you are a for-profit organization, you cannot accept volunteer work. You must compensate those employees. They can volunteer for nonprofit organizations. However, it must be truly voluntary. It cannot be at the end of 38 hours that the supervisor says, all those who want to volunteer to work an extra 4, raise your hand. It must be truly voluntary. The work that's being done cannot replace an employee, and the work that's being done cannot be the work that the employee is doing. Again, you can't volunteer to work overtime so that you don't have to be paid. But some volunteer work can be done without compensation. The last question that is fully loaded and far longer than I'm going to be able to answer is, so does this mean that annual conferences and churches without an embedded school are not covered by the FLSA? The answer to that is there is no way I'm going to answer that on a 30-second answer on a telephone call. But I will tell you that generally churches that are not operating anything that would be generating revenue, commercial revenue of $500,000 and do not have a school, most likely would not be covered as an enterprise. They may still have individuals who are covered under the individual exemption. Annual conferences are even more difficult because it'll depend on what other operations they may be engaged in. Are they generating any types of revenue? Do they have any particular facilities that may rent out or generate revenue? So there is no one-size-fits-all answer to that question. And again, keeping in mind that for either one of those groups, even if you're not covered under the enterprise, you may still be covered, or individual employees may still be covered. I'm going to look for some other questions, but I'm going to turn this over to Mr. Lambert at this point to talk a little bit more about compliance HR.
Thank you, Eric. I appreciate your time and as always, the informative nature of your presentation. I did want to mention a bit about where we're going, where we would like to go in terms of path forward. As I mentioned to you before, we've gotten a number of questions already from you and others in annual conferences and other organizations within the church about this topic, and we want to continue to get your questions. As we get them, we'll answer them as quickly as we can, and as we get questions that are applicable to everyone, we will make sure that each of you who are participating today see the questions that we get and our answers. We will include Eric as we need and go forward. With regard to the software program, let me just say we're very serious about this offering and this opportunity. I have tried it on upwards of 5 or 6 different employees myself. I can do it. I'm sure you can. It's not that difficult. It is intuitive. It is cost-effective. We have purchased a license. Currently, I'll just tell you, it's at $60 an employee search, and that's what we're passing on the cost to each of you who wish to do it on your employees. There's no minimum number of employees that you need to search. It's simply a $60 per employee test per unit. So I think you should at least try this. It is state-of-the-art and very helpful, at least in my view. So I will turn this back over to Eric if he has any other questions. And Eric, do you have another one?
We do have some other questions, and Corey is just, for sake of time, is just going to read them off of the screen.
Okay, one of the first questions that come in asks, what about housing costs when you provide a house for a camp director?
Housing that is provided for an employee may be counted towards compensation for the employee. The housing, only the fair value of the housing can be provided. Having worked at some camps in the past, fair market value of some of those houses, I'm not sure what they would be. But nonetheless, the housing itself certainly can be counted towards the compensation of the employee, but again, it has to be the fair market value of the housing. You can't simply set a value that might be above fair market value.
Another question came through is what about youth pastors on mission trips? Not licensed ministers, but youth pastors.
Youth pastors pose a difficult question because I have seen some situations where they have been found to fall within the ministerial exception, but that I would not rest myself on that because, again, if they truly are not, they are not ordained, if they have no seminary training, if they are now, again, they may be a camp counselor, and if that's even though they may have the title of youth counselor, if they are also acting as a camp counselor, if the camp is exempt, they may fall within that as well. I would not, as we've talked about before in terms of titles, simply referring to an individual as a minister is not in and of itself going to exempt someone under the ministerial exemption. Yeah.
The question is, how do we handle stipend positions? We pay our organist and some other annual stipends.
It is likely that a church musician is not going to be working over 40 hours a week unless that is a full-time position. And so oftentimes that's not going to be an issue for overtime. It may be an issue for minimum wage. If again, the organist may fall within the professional exemption, but then that may require some higher compensation than what you're paying. A stipend can be paid as long as you calculate the hours that they've worked and that those hours multiplied by the minimum wage is at least as much as the stipend. So a stipend is probably going to be okay. You do need to have some idea of the amount of time that they are working, making sure that you are that stipend at least covers minimum wage.
Thank you, Eric. Again, we'll be truthful to our hour-long promise for the presentation, and thank you for participating. Be watchful. We'll be sending you additional information in the next day or so. Thank you very much.